So the topic that we have today, has its origin placed sometime in 12th century. So the concept is really as old as that, but it became a common feature of friendships, cultural trade, navigation treaties, sometime in 18th and 19th century. But yes, MFN from a tax point of view, gained significant importance over the last decades, and a lot of international tax treaties really have that mention about MFN clause, and its application around different types of income streams that get generated. A lot of Indian treaties also have this peculiarity added, though none of the model conventions, neither OECD model convention nor UN model convention nor US model convention, really have a specific language around MFN per se. And the reason primarily is because MFN is most favored nations clause, and the fundamentals of MFN are really governed by reciprocity and economic bilateral economic cooperation between the two countries, and it is not something which is a matter of law by default, and hence it doesn't find its place in the OECD or UN model convention in that sense. Though there is no special mention or special MFN language in any of these model conventions, at least WTO embraces MFN as a cornerstone principle of international trade. And that primarily is because it is not really only a tax topic. It is a concept which cuts across different dimensions of businesses. There are trade agreements which have, in a similar fashion, a MFN clause. And when it comes to tax, the application is, of course, far more specific. Now, there are a lot of nuances, a lot of technicalities, a lot of interpretations associated with MFN as a subject, because it's been part of the Indian treaties really for far too long, and we've had a lot of jurisprudence in India, and the latest one being the circular that was issued by the CBDT earlier this month. Now, what we intend to do today is, in next 90 minutes or so, we intend to focus on some of the critical fallouts of this circular, which the CBDT issued, and what are the different controversies that it tries to address, and what are the new controversies that are likely to pop up in context of this new circular. Like I said, there are different number of other issues that are also associated with MFN. We'll try and also exchange insights on that as well. But I think the primary focus for us today will be two important controversies that really are fallout of this circular. Again, and what we also intend to do is, initial part of our discussion today, we'll want to go back to the basics of MFN, because MFN as a topic has the kind of controversies that this topic has been embroiled in, really requires one to go back to the basic aspects of what a tax treaty is, and how interpretation for a tax treaty would be different, or would stand on a different footing as compared to interpretation of a tax law per se. The primary objective of MFN is really that state which has signed a treaty with the other country is not prejudiced by a favorable treatment that the other countries now started to give to a third country. And MFN really is a mechanism to also bring within its ambit any benefit that the other contracting party is giving to a third nation. So all of that from a tax perspective really needs to fold together, and that is the construct and objective of MFN clause. Now, what you see on the slide is primarily the flow of our discussion today. Like I said, we want to go back and very briefly touch upon some of the basic yet very, very crucial elements, because that is core to the understanding of the topic around MFN, and something that will help us interpret all these complexities that are surrounded in this context of MFN. Now, we'll start with treaty interpretations. We'll also want to look at how different treaties bring in a MFN element. Most of them in Indian context bring it in through a protocol. Some of them also have a more specific language added in the core text of the treaty itself. Then we'll talk about some of the critical aspects, key features of MFN, and again, we'll try and focus our discussions only in Indian context, with critical references coming in from other countries as well, because again, for interpreting some of these issues, there is guiding light that can easily be seen in some of the other countries which have been very prominent in signing MFN clause in their tax treaties, whether it's South Africa or Australia. Then we'll move to some of the critical issues that are now associated with MFN clause, primarily the two issues that the circular is giving rise to. We'll talk about some of the Indian rulings and the foreign decrees on MFN, talk about the CBDT impact and a more granular level of impact analysis for us to go back and look at different situations to apply MFN henceforth. And of course, then the talk of the town is also on what is the binding nature of this circular. We'll touch upon that briefly, and then finally the idea is to consolidate all the learnings, all the takeaways, all the key considerations associated with MFN as a topic. We'll move on. I think the first part that needs to be understood and needs to be very clear is tax treaty is a document that is signed by two national jurisdictions, two countries, and this is primarily to regulate taxes. And there are different objectives with which a tax treaty is signed. It could be promotion of trade, it could be elimination of double taxation, and so on. Taxpayer is never a party to a tax treaty. And the construct of a tax treaty is such that at the end of the day, it is an agreement, a commercial agreement signed between two countries, and that is something that needs to be kept at the heart of the issue when we look at different nuances of MFN as such, because that is really what will define the interpretational rules for a tax treaty vis-a-vis core provision of tax law. Now, treaty, of course, represents different dimensions, whether it is right to be foregone, limiting scope or rate of taxation, credit, etc. And the fundamental reason why governments sign a tax treaty is to keep the trade and commerce in perspective and ensure that their share of tax, looking at the trade and commerce, is really aligned as per their respective intentions. And like Vogel rightly says, a tax treaty neither generates a tax claim that does not otherwise exist under the domestic law, nor does it expand or alter the type of an existing claim. And I think that is a very critical statement to put things in perspective when we look at some specific controversies around MFN. We'll move on. Right. And when one looks at tax treaties, I think the core Bible for one to interpret tax treaty is Vienna Convention. India is not a signatory to Vienna Convention, but that doesn't necessarily mean that Vienna Convention doesn't necessarily have a lot of say when it comes to interpretation of treaties or treaty concepts like MFN in Indian context, because there have been number of occasions, including the famous Supreme Court decision in Azadi Bachao, or Mr. Ramjit Mulani, where Supreme Court was seen taking reference from the Vienna Convention to interpret different aspects of tax treaties. Like we have different rules for interpretation of tax laws, Article 31 and 32 of Vienna Convention is what provides for interpretational rules around tax treaties. And one important dimension, including Article 26, what really comes out from these three articles, Article 26, Article 31, and Article 32, is treaty must be performed and interpreted in good faith. And the reason why that becomes important is some of the controversies that are now turned out into burning issues have really put us at the put the taxpayer community at a situation where different countries have different interpretations of the same issue. And like I said at the start, at the end of the day, tax treaty is a commercial contract between two countries. And what happens if two parties to a contract do not carry the same meaning for a particular term? It goes into dispute, it goes into arbitration, right? So now, what is the course of action that is likely to happen? One will have to wait and watch. But the guiding principle, as and when it reaches that stage where a neutral entity comes into play and really resolves the dispute, is the fact that it's a treaty, it's a commercial agreement, and it needs to be interpreted in good faith. And there are the debate can go on and on, specifically on the debate basically around whether MFN benefit should be extended to countries or should be extended for import from countries which were not OECD members previously but became OECD members now. And we'll talk about all of that in greater detail later on. this one really capture some of the quotes from foreign jurisprudence, legal commentaries on how treaty should not be treated as per the technical rules, something that we've discussed already. And the core function of treaty should be seen to aid commercial relations and equitable distribution of tax revenues. We'll turn the page now, and I think the important part that we should now dive into is the protocol to a tax treaty. Now, again, MFN as a clause, I think the basic part around MFN is, it, like I said, it does not have a standard language in any of the conventions, but it typically find its place in what is called as protocol to a tax treaty. Okay, and protocol is a extension of the tax treaty. When you look at the tax treaty comprehensively, article 1 to article 28, 29, 30, and so on, and then after the end of the treaty you find what is called as the protocol, and protocol defines how do you interpret some of the clauses which are already captured in the tax treaty. And from a MFN point of view, this is where most of the times in Indian context you find MFN clause coming into play and defining how the MFN operate will really look like, and which really makes it important for us to understand the concept of protocol and understand how it is relevant in the current context. Like I said, it can be found either in the core tax treaty itself or in the protocol to the tax treaty. And there has been considerable amount of debate on whether a MFN clause which is part of the tax treaty, is it really an indispensable part of the treaty itself, or is it a document which is more like an aid to the tax treaty interpretation? And there have been several rulings in Indian context, which are aligned with the global understanding of protocol, that protocol is an indispensable part of the tax treaty. It is something that you need to read along with the tax treaty articles, because again, how a protocol is drafted, it makes reference to specific articles from the treaty, and then one needs to interpret the article language along with what is mentioned in the protocol. So from a global point of view, I think the debate is clearly settled as far as the issue around whether protocol is an indispensable part of the treaty or not, and the global verdict there is clearly a yes. And I think even in India, I mean, you have a Kolkata ITAT ruling in ITC, which really delved into this issue quite significantly. Then that got followed in Delhi High Court ruling in Steria, and a number of other judgments. In some cases, what we also see is the debate has gone even further. And when one looks at India-US treaty, apart from what you find as a protocol in different countries, tax treaties, in US, all of us know there is a specific explanatory memorandum which gives some illustrations in terms of how do you interpret different situations, and whether some specific situations which are captured therein will really form part of, or whether how will the tax treatment really work about on some of those specific situations which are covered by way of illustration. And the fundamental debate that came up in a decision in context of Shell Global by Ahmedabad Tribunal is that whether such explanatory memorandum to US treaty is also something that one needs to import along with the favorable language from India US. And the moot point being whether while interpreting a different treaty, and due to MFN clause one imports a favorable language from India US treaty, whether one needs to restrict that import only to specific article, or whether one can go also to the extent of importing favorable explanations from the MOU to India US. And there has been a tribunal decision which has answered this question in positive. So the sum and substance of what I'm trying to say here is MFN usually finds its place in protocol. I think the debate there is from an Indian point of view and from the global point of view, lopsided and settled in favor of the taxpayers, that protocol is an indispensable part of the treaty. There have been some stray cases where not just the protocol, but something like an explanatory memorandum to India US has also been imported into the tax treaty. Yes, I think this is a code which has been famously used in different decisions from Mr. Klaus Vogel. And again, we don't need to go through the text there, but we just thought we'll flash it here because this is been at a focal point of the Delhi High Court decision in context of concentrics as well, which we'll come and discuss in greater detail. what we intend to do is really set the characters for our discussion very clearly, and then when we talk about the critical issues on MFN and the concept, we have all the characters fairly established. Now, MFN, we've spoken a bit about this, but what it seeks to do is it extends similar benefits to one country as I extended to certain other countries. A debate that popularly comes up in context of MFN is whether MFN clause gets triggered automatically or whether there is something that needs to be done to trigger the operation of MFN clause. Now, one view of the matter, at least the tax authorities have been consistently taking a view, and something that the CBDT circular now very strongly advocates, is that MFN clause is not automatic in its operation, and it needs an artificial trigger for it to be set in motion. Whereas the popular global understanding and the understanding that a lot of Indian courts have followed is MFN clause by and large will be automatic in operation unless the language of the clause itself seems to suggest otherwise. And we'll come to those two distinguishing parts as well. But from an Indian point of view, what you also see on the slide is there are a number of treaties where India has agreed for a MFN clause, and a number of them are with OECD member states, and then some with non-OECD member states. And the reason why we are distinguishing this, putting a separate list out for OECD and non-OECD is because when you look at the MFN clause in a OECD country, you also find that there is a specific need created or a requirement created to import MFN clause only from the treaties signed with other OECD members. You can't import what is there in a non-OECD treaty into a OECD treaty by and large. And that is why it's important to look at that list separately. Whereas in context of non-OECD, the language is different and they don't really carry a specific requirement around that. Right. And the underlying principle for MFN clause is to ensure that there is no discrimination. The favorable treatment is transferred to the other treaty partner in a level playing field. And what has also emerged in the recent time is some tax experts globally also believe, and this is also at the heart of the OECD BEPS pillar 1 of the BEPS 2.0 program, that the MFN clause has perhaps outlived its utility because from the time when MFN was first introduced in tax treaties popularly in 18th and 19th centuries, I think from then till now, a lot has changed in terms of, now there is a greater emphasis on ensuring that there is a minimum rate of tax that is collected by source jurisdiction by way of a specific rule in pillar 1, pillar 2 concept. So all of that will also come into play, and there is something that we want to discuss in greater detail on that as well. But moving on, I think the other part that needs to be clearly understood is there are some specific critical aspects on how you understand and interpret a MFN clause. Okay, now MFN is not necessarily required to be reciprocal, though the construct of MFN, when it gets agreed between two parties, two countries, they will really look at the economic relations between them, the trade and commerce, and how a specific MFN clause in a tax treaty is going to augment the trade and commerce further. But fact of the matter is there are enough examples that the operation of MFN clause need not necessarily be automatic. And a simple example to that is India-France treaty. When you look at India-France, what it says is, if after concluding India-France treaty, India extends favorable treatment to another OECD country, then that favorable treatment will get imported into India-France. But if France were to grant a favorable benefit to another OECD country later on after signing of India-France treaty, then that does not get covered, or that does not get imported into India-France by way of MFN clause present in India-France. So that is what we mean by the fact that MFN clause does not by itself necessarily has to be reciprocal, because there could be some examples where the language and the treatment needs to be different. Then there are other popular examples, and some popular use cases specifically in Indian context for MFN include for passive sources of income like technical service fees, royalties, interest, etc., or dividend, more importantly now, after the change in law from April 2020. So these are the passive sources of income which typically are the ones that you look at from a MFN point of view. But there are some treaties where you also look at something like a business profit, because in context of expense deduction that is allowed to a PE that a foreign enterprise creates in the source state. There are instances like in case of India UK treaty, where it says that if there is a more liberal treatment that India gives to another OECD member subsequently for in context of expense deduction for while calculating income of a PE, then that treatment needs to be imported into India UK as well. So the point that I'm trying to make is the popular understanding of MFN is that it usually applies to a royalty or a fees for technical service or dividend or interest. But yes, there could be each MFN clause in each treaty is perhaps worded differently. There are unique features to each one of them, and there could be examples like a business profit, Article 7 as well, where one may need to bring in an element of MFN as well. And some of the other popular examples in the same context could be where an Indian company having a foreign branch is making payment to another non-resident. Now, a foreign branch is still treated as a resident in Indian context, and the payment is still a payment from an Indian resident to a non-resident. And when one applies the tax treaty, there are some treaties which allow a more favorable treatment in terms of not giving India the right to tax that transaction, whereas most of the other countries do give India that right. And whether one can use Article 5 read with Article 7 type of interpretation along with MFN to borrow and import the favorable language in that context is a matter of evaluation in specific facts. So the point being, there are use cases even beyond royalty, FTS, dividend and interest as well. And the part that I was mentioning earlier, is whether MFN clause in its operation is automatic, or is there something that needs to be done in terms of some affirmative action that the governments need to take before setting MFN clause in motion. Now, when you look at India-Belgium treaty, it is one treaty which specifically says that its operation will really be the date of India-Belgium treaty or the date when this treaty is signed between India and the third country, and whichever is later, and that is how it automatically sets the MFN clause in motion. Whereas there are treaties like after the 2010 amendment to India's Swiss treaty, it specifically adds a language that where India is seen giving benefit to a third country, India and Switzerland will enter into a renegotiation and then finally call out what needs to be done in context of that benefit for India-Switzerland treaty. Likewise, Finland has a similar requirement to before extending a benefit, you inform the competent authorities and there is a need for issuance of a notification, etc. So there are some treaties where the operation is not entirely automatic, but bulk of the Indian treaties as well fall in the first category where the operation is more automatic. So when one looks at the MFN applicability in Indian context, I think there are two relevant dates that one needs to keep in mind. First is when you look at your specific facts of the case, you need to determine if the MFN clause is present in the treaty that is applicable to you, then you need to draw a cutoff for selecting the treaty to be imported into the MFN through the MFN clause. That is point number one. And that cutoff will depend on the specific language. There are treaties like, I think, India-Sweden, which does not specifically say that the treaty from which you want to borrow the favorable language has to be signed only after the treaty under consideration. Whereas there are treaties like Belgium, like I mentioned, which specifically say that only a treaty that is signed subsequent to India-Belgium will you look at to import the benefit into India, into the specific treaty. So again, each treaty will have its own specific application, but the exercise that will first have to be done is one will need to draw a cutoff date for selection of treaty to be imported into your facts through the MFN clause, and that will depend on what is the specific language that you have in the facts of your case. The second part will be when is it that the MFN clause can be said to be effective, taking us back to the earlier debate on whether it is automatic or it is not automatic. And though what we discussed is only one dimension of the matter, and Indian tax administration would like to believe otherwise, and we'll get into those details as well. But primarily from a date point of view, these are the two dimensions that one really needs to look at. This is a short illustrative example of a classical situation where you may end up looking at a MFN trigger. Now you have a situation where you see a, a Spanish company rendering some services to an Indian company, and the tax treaty really has a high rate of 20%, and one ideally would go under the domestic law and do a withholding at domestic law rate itself. But just for illustration purpose, if the domestic law rate is kept aside for a moment for a theoretical discussion, the because of the MFN clause in India Spain treaty, what one really can do is look at two aspects. One is the possibility to take a more restricted scope from another treaty, like a India US, which has a restricted scope for technical services, or India Greece treaty, which is signed long back. So perhaps Greece may not actually get imported into India Spain, but India Greece has a peculiar feature that it does not have a FTS clause itself. And the view of the matter then possibly could be, in absence of a specific article on fees for technical services, you go back to Article 7, which is business profits, and unless the foreign enterprise has a P in India, you don't consider that transaction to be taxable. But again, the point of the matter is, when you look at MFN, you have two dimensions to look at. One is restricted scope, from India US or India Portugal. You look at you apply the parameters, draw the cutoff, and see what you can do. Assuming, despite importing a favorable treaty language, into India Spain, you still find this income to be taxable. But because the treaty rate is 20%, then the next choice would be to bring in a lower rate from other treaty, and that is what this illustration really shows on the left hand side. Then on right hand side, what you see is some more popular use cases. When it comes to India Netherlands, it has a fairly broad definition of fees for technical services. Again, one can look at importing a India US. India US has a fees for included services concept, which says that something will be considered to be fees for included services only if it is in context of payments for some design, etc. Or if that service really ends up making available the underlying knowledge to the recipient. And that is the restricted definition that one can look to import within India Netherlands by using the MFN clause there. Then likewise, more examples for the India Hungary treaty, for you to be looking at interest on government securities to be non-taxable, by importing a favorable language from Italy or Portugal. And Belgium again is an interesting example. When you look at the royalty definition under the domestic law, it is fairly wide. It includes equipment royalty as well, payment for right to use the equipment. And similar is the definition under the India-Belgium tax treaty. But India-Belgium allows you to import a favorable language from India-Sweden, and India-Sweden has a more restricted definition for equipment royalty. So that could be an interesting mix of things here. And again, these are only a few illustrative examples. What one really needs to go back is look at the specific treaty, draw your cutoff, look at the specific dates, identify the treaties that you can import favorable language from, whether it is restricted scope or lower treaty, and then look at the idea should be to restrict and reduce the number of controversies that finally end up in your case. And then as we go along, we'll also talk about what those controversies could be and a possible resolution and approach to that. We'll move on now. What you see on the slide now is just the illustrative language in some of India's tax treaties as to how MFN clause is really worded. Now, like I said earlier, India-Sweden does not necessarily create a condition for the treaty from where you want to import the favorable language to be signed subsequent to India-Sweden. So it's fairly open-ended in that sense. So one view of the matter would be to whether one can import favorable language from a treaty which was signed before India-Sweden as well, like India-Greece. And I would say it is definitely possible and needs to be looked at that when you don't have a precedent for that specific issue in Indian context, I think. But if one looks at a South African ruling, there is some guidance coming from those lines, because Sweden has maintained this kind of language in its treaties with different countries, including South Africa. And South African court once had an occasion to examine this issue, where they say that in absence of a specific condition in the MFN language, which creates a need to go to only subsequent treaty, in absence of that language, the Supreme Court in South Africa really ruled in favor of the taxpayer and said you can go back and import favorable language even from the older treaties as well. Then with France, you see a different dimension, a different illustration of how MFN clause is worded, and it really sets out a date that after this particular date, you can go back, you can look at treaties which are signed after that date and then import MFN clause only from those treaties. Then India, Switzerland, with that renegotiation that happened, I think in 2010 was another negotiation that happened, and some change that happened to the MFN language in India, Swiss. And what it says is, if India is found giving benefit to a third OECD country which is more restricted scope or lower rate, then Switzerland and India shall enter into negotiation without undue delay in order to provide the same treatment and all that. So it really follows that trail after 2010. Then you have a similar example for Philippines, where the language is that the two governments will come together and undertake a review of these articles to really then decide on how to, and if there is need to extend such lower rate or restricted scope to the case under consideration. So what we intended to do here is give you a fair mix of treaty languages that India has when it comes to MFN clauses, and how each treaty is differently worded, and therefore the kind of issues that one will have to deal with in each treaty will perhaps be different. We'll move on now. Now, another issue that became a part of recent circular that the CBDT issued is in context of India's treaties with Slovenia and Lithuania. And what it primarily does is, after 1st April 2020, when India moved back to the dividend withholding tax regime from the dividend distribution tax regime, a point of controversy that became more prevalent, not just that it was not relevant earlier, because there are some interpretations that were tilted on similar lines even prior to 1st April 2020. But by and large, what it tries to do is, it says that India has entered into a favorable treaty with Slovenia and Lithuania, where the tax rate for dividend is 5%. And there is another country, I think Colombia, where the tax rate is 5%. But with these two countries, it's 5% as long as the shareholder holds more than 10% in the company declaring dividend. The peculiarity with these two countries is, these two countries were not OECD members when India signed those treaties. They became OECD members only later on. And hence the point that comes into play is something that the circular is also thrown up popularly is, circular seems to create a requirement that these two should have been the OECD members for one to be able to import a 5% from these treaties. And it's a very interesting issue, and we'll talk about that in greater detail in some time. But yes, I think we just wanted to also give a specific language on how Slovenia, Lithuania, and some of these newer treaties where there is 5% rate for dividend got signed, and something that will come handy when we talk about that issue in greater detail. Okay, what you have now is a short timeline, because this is what is going to be important for us to get into our discussion for those two specific issues that we really want to focus on today. Between 89 to 95, you had different treaties that got signed. 94, you had India, Netherlands, India, France, Switzerland getting signed. India, Slovenia got signed in 2005. Slovenia became a OECD member sometime in 2010. And then in 2012, Netherlands issued a decree in wide range of countries, including India, stating that for dividends that are issued by a Dutch company to, say, an Indian shareholder, the tax treatment in Netherlands will really follow the beneficial treatment after allowing the import from Slovenia, which, by the way, was not a OECD member when the treaty was signed, but became a OECD member later on. So it specifically allowed a retrospective import, but from 2010, which is the date when Slovenia became a OECD member. So Netherlands specifically issued a decree supporting a view which is favoring the taxpayer, and something that is now a boiling point, at the boiling point in India, specifically after that circular. Then you had India, Lithuania, and India, Colombia getting signed. France followed the suit, in 2016, and followed the same treatment that Netherlands had extended in 2012. Then you had Lithuania becoming a OECD member in 2018, Colombia becoming a OECD member in 2020, and finally, sometime last year, August, we saw Switzerland specifically allowing 5% benefit, for dividends being paid by Swiss companies to Indian companies for their domestic law treatment. And I think that is one important dimension that will get discussed in greater detail now. The other key takeaway from this slide is, why we wanted to ensure that all of us are on the same page when it comes to the timeline, is because India had a change in dividend tax regime, and dividend is one important consideration, because it is one of those passive source income where MFN will have a play, continues to have a play. So only Switzerland issued this decree after India moved to the DDT regime, but all the earlier decrees were issued from an India point of view. They were issued at a point in time where India still had dividend distribution tax, because they were issued looking at their local domestic law tax requirements, and they were issued in favor of the taxpayer as far as their domestic law is concerned. But now India is more interested, because if India were to reciprocate that treatment, India would end up losing on the tax revenue there. And that is one fundamental reason why India has really debated that out, and the CBDT came up with that circular which does not allow this benefit. So we'll move on now, and I think the two issues, the discussion that we've had so far, finally brings us to two important issues that we want to really talk about in greater detail. And maybe I'll just spell out the issues, and take a pause if there are any questions so far, and then we can move to discuss these two issues in greater detail. The first issue that comes to the fore after this, after everything that we've discussed so far, is whether third state has to be a OECD member, both at the time when the treaty was signed with India and at the time of applicability, or is it okay if the third state is a OECD member at the point in time when you want to apply or import the benefit from that treaty. So that's issue number one, which is more specific, as far as things got discovered, which is more specific in context of dividend income. The other issue is more fundamental and far more broader, because it somewhere seeks to create a overarching need for a notification to make the MFN clause operational in the first place. So what it says is whether one needs to have a separate notification being issued by India for MFN clause in different treaties to be effective and operational, or whether the MFN clause that we saw in different treaties is automatic and self-operational on its own. And there are fair bit of judicial precedents on the second issue and on the first issue as well. So these are the two issues that we intend to focus on from here on. But I'll take a pause, and if there are any questions, we'll try and address them first and then move to the second part. Okay, I see one question it's in context of reciprocal concept in detail with respect to France. Okay. So what we discussed is the concept of MFN per se finds its genesis in the concept of reciprocity, right? But there are specific instances, like in case of India, France, which says that if after the treaty between India and France is signed, after signing of that treaty, if India allows favorable treatment for taxation of dividend, fees for technical services, royalties, or interest to a third party or a third country which is a OECD member, then that favorable treatment will stand imported into India, France. And for the moment, I'm keeping these two issues aside, what you see on the slide, because we just want to focus on the concept of how the reciprocal MFN application would work. Now, because India, France has that specific requirement which only allows a subsequent import from a treaty which India has signed with a OECD country, it does not specifically cover a situation where no, let's say France, no, now France has a large treaty network, and I think it had even before France and India signed the treaty. But let's say hypothetically, if France and Germany did not have a treaty at that point in time, let's say India, France got signed first, and after that, if France signed a treaty with Germany, saying that dividend will be exempt, and the source country will not have the right to tax dividend, then that treatment cannot be imported into India, France, because the way the protocol is worded, it says if India allows subsequent benefit, that will get imported. But if France allows that, there is no room for importing of that. And that is what I meant by saying it is not necessarily reciprocal. I hope that point is clear now. So if there are any further questions, I can take a quick pause now and we can debate that right now. Otherwise, Hina, if you are okay, we can move to the next part of our discussion, and the core two issues that we identified for discussion with this group.
Yeah, I think just Manoj, we can give a 5-minute timeline. We have one more question. Let us address that as well. And in case any member wishes to raise hands, they can raise hand and put up their question as well. So just give a 5-minute timeline so that then we can move to the second part of it.
Right. I think there is, I can see only one question which we addressed on the reciprocal concept with respect to France. Is there another question that I can't see?
Sorry. No, there's no other question. Okay, I think you should move ahead.
Okay, thank you. Right, so these are the two issues that are at the fulcrum of the debate right now, and something that will really need attention in context of application of MFN in different instances, different treaties, and something that we want to now get into slightly more detail. So I'll invite my colleague Mohit now to really spell out these issues in greater detail for us and take us through that.
Sure. Thank you, Manoj. So yeah, basically, as far as the MFN invocation is concerned, I think two issues that we have identified are the ones which have occupied large part of the debate as far as the Indian tax landscape is concerned. The first one being whether MFN benefit can be invoked from a country who was not an OECD member at the time of signing of the treaty. Now, this issue is why this issue creates a lot of significance also is that maybe the benefit that is there in that particular treaty would be pursuant to a fact specific or some peculiar understanding that might be there between the two countries, and might not be something that that can be seen at large OECD level, and that's why this controversy stays. Another fact that has really aggravated this controversy is the kind of decrees that have been issued by the foreign tax authorities. And that has really aggravated the issue with respect to whether a MFN benefit can be invoked from a country which was not an OECD member. If you move to the next slide, we'll see that there have been various degrees that have been issued, and how the overseas authorities have kind of interpreted their thought process on the application of MFN clause. So as far as Swiss authorities are concerned, they have kind of taken a MFN benefit from the two concluded tax treaties, that in case of Lithuania and Colombia, which were not the OECD members when they were entering into the treaty with India, and they became OECD members at a later point of time. And pursuant to those treaties, any dividend transaction that was between any dividend transaction which was getting taxed pursuant to a treaty between India and Switzerland, the SSEs have been kind of taking a recourse to the reduced rate of tax at the rate of 5%. So Swiss authorities kind of gave their thumbs up to these treaties, and kind of gave a statement on very recently in the month of August 2021, and really said that the Lithuania's and Colombia's accession to the OECD has the effect of retroactively reducing the tax rate as far as the dividend taxation is concerned. So this was one point wherein this controversy with respect to whether a benefit from a non-OECD member could be invoked at the time of concluding a dividend transaction. Another statement was has been issued by the Netherlands with respect to Slovenia. Slovenia, again, likewise in case of Lithuania and Colombia, became an OECD member in 2010, whereas the treaty with India it had signed during 2005 itself. So Netherlands kind of also adhere to the similar observation as done by the Swiss authorities, and mentioned that the dividend taxation will be applied at a beneficial rate as present in the treaty with Slovenia, even though that Slovenia was not an OECD member at the time of signing of the treaty. So the issue really aggravated from here, and there have been similar kind of issues have been dealt before the Indian tax courts as well. One of the case laws which has been really a landmark in that sense is concentric services, which we will discuss here. If we move to the next slide, is with respect to concentric services, wherein the Delhi High Court has given its ruling. Now, the facts of the case are like an Indian company who is who's a subsidiary of a Netherlands-based concentric services. It has really applied for a lower withholding tax certificate at 5%, thereby invoking the MFN benefit that is there available in the India-Slovenia tax treaty. The tax authorities really did not consider that MFN benefit, and they stipulated a tax of 10%, basis the tax rate which is available in the India-Netherlands tax treaty itself. So here, if we look at the facts, the argument put forth by the tax authorities were pretty much similar what we have been discussing, that Slovenia was not a member of the OECD at the time when it was agreeing a treaty with India. So benefit of benefit with respect to a lower or restricted tax rate which was extended to Slovenia was extended in their own right, and not because they were the members of OECD. And hence, the tax authorities or the revenue really argued that the benefit of the lower rate of withholding would extend to the countries which were the member of OECD at the time of signing of the treaty, and that would be a relevant date from when we look at importing the MFN benefit. However, the Delhi High Court in this case really considered the overall global jurisprudence as far as the interpretation of MFN is concerned, and they mentioned that the use of the word in MFN clause is in the sentence which is a member of the OECD. So it requires a kind of a liberal interpretation, and requires country to be OECD members when the source taxation is triggered in India, and not at the time when the subject treaty was executed. So this was something that the Delhi High Court really pressed upon while dismissing the arguments put forth by the revenue. Another aspect which was raised in the ruling of concentric services with respect to whether a notification is required. So again, that we can take up in the next ruling where we discuss the issue at a greater detail, and this particularly in case of Delhi High Court ruling in Syria, India, which was also kind of followed in the ruling of concentric services. So basically, this was the issue. This is the whole argument around whether a MFN benefit can be taken from a country which was not an OECD member, and has been clarified in the circular later on by the CBDT. The second important and the fundamental issue with respect to MFN is whether a notification is required. Now the CBDT is of the view that once you invoke a MFN benefit from other treaty, it primarily results in an amendment to a tax treaty, and hence, since it results in amendment to a tax treaty, the same can be implemented only by way of a notification, and not, it does not require an automatic invocation, as it has been interpreted by the taxpayers, or in the overseas tax landscape as well. We have discussed in the past that how the MFN generally form parts of the protocol of a tax treaty, and protocol as such only forms an aid for the interpretation of the tax treaty, and forms very much part of the tax treaty itself. And therefore, there have been various arguments to counter the CBDT view in this regard. Um, there are some tax treaties wherein there are specific conditions for having a notification or some affirmation by the tax authorities in place. Like if we consider India-Swiss treaty, the treaty is subject to additional negotiation with respect to MFN clause application for royalty or FTS. There has been a ruling from a Torrent Pharma, Ahmedabad ITT ruling in case of Torrent Pharma, wherein the ITT has ruled that application of amendment clause was subject to an additional negotiation from the Swiss government, and hence these are some treaties wherein there have been provisions in place, and which suggests that a notification would be required to invoke a MFN benefit. However, in most of the treaties which we see, apart from Switzerland or few articles which are there, otherwise, as far as the interpretation is concerned, it is clear that MFN can be invoked without any additional notification of any countries. So this is how the controversy has arisen, and again, so unilateral interpretation and instruments. So basically, the decrees or notification that has been issued by the tax treaties are itself unilateral in nature, and as such not binding on the treaty partners. So similarly, the any circular that has been issued by the Indian Tax Authority, whether it will be binding on the treaties entered by India and the treaty partner, is something that is still not clear and may act as a double-edged sword. So moving on, if we see the landmark ruling in case of Syria India Limited, which kind of put a tax authority's point of view on the invocation of whether a notification is required for an invocation of MFN clause. The facts really were that Syria India was supposed to pay some management fee for managerial services to Syria France, and they applied before the authority of advanced ruling for whether at what rate they would be able to tax this payment. So the matter was before the AR, and all the facts were put in place, wherein the AR rejected so the agreement, the treaties which were in operation were between India and France. However, the SSC relied on the provisions of DTAA and the protocol that was there between India and UK, and as per the India-UK treaty, the scope or the ambit of the term of FTS was more restrictive as compared to India-France, and that's how the SSC kind of contended that the less restrictive definition which is there in the India-UK DTAA must be imported in the India-France DTAA as well. However, the AR rejected this plea and kind of ruled that protocol could not be treated as a forming part of the DTAA itself, and it kind of said that the make available clause which is there in the India-UK DTAA could not be read into the expression of FTS occurring in the India-French DTAA unless there is some notification given by the government to incorporate the less restrictive provision. So again, what the AR suggested was that there has to be notification in place for importing the make available clause that is there in the India-UK DTAA. So the Syria India went before the Delhi High Court against the observations of the AR, and put forth its argument, with respect to whether a notification is required. So looking at overall case, the High Court observed that the protocol which is there in the India and France DDAA, and the less restrictive FTA's definition as present in UK India DDAA must be read as forming part of the India France DDAA as well. And kind of the High Court also appreciated the fact that the protocol is an integral part of a tax treaty, and the same and should be treated same and likewise as a normal article of a DDAA.
Mohit, if I may just come in and
sure.
quickly to summarize, see,
yeah,
I think like we discussed at the start, we identified two critical issues that, and Hina also mentioned that two burning issues coming out of the circular. We spoke about that, we spelled them out. And what we see is there is a favorable High Court decision from each one of them, right? So there is a Delhi High Court decision in case of Styria, which overrides a negative advance ruling in Styria's case. And the issue over there that was set to rest by the Delhi High Court was that one does not need a separate act of or a affirmative act to make the MFN clause operational unless it is specifically mentioned in the treaty. And the treaty under consideration was India-France, which didn't really have that kind of language. So the net conclusion for Delhi High Court in Styria was no need for a separate notification to make MFN clause operational. And that was the final conclusion from the Delhi High Court on issue number 2. And the matter is still pending before the Supreme Court, and one will have to wait and watch in terms of what the final law of land is. But if one really extrapolates this issue to the global landscape, I think by far this is quite clear and quite aligned with the global understanding that one does not need to read a incremental requirement of issuing a circular or a notification to make MFN clause effective. Because, and again, in Indian context itself, one gets that distinction when one looks at a India-Finland treaty or a India-Switzerland treaty, which really, within the language of the MFN itself, creates that incremental requirement for issue of a notification now, which is not there in India-France, which is not there in India-Sweden, and so on. So that's really the second part of the second issue that we spelled out. The first one on whether the country needs to be a OECD country at the time of signing of that agreement, or is it okay if the country from where you want to import favorable language became a OECD country later on? I think that debate is far from over, because in Indian context, there aren't too many jurisprudence. What we have so far is favorable to the taxpayers, and again on that there are some there is some point of view from a when one looks at the global precedents. Again, when one looks at Australian tax treaties, Australia also has fair share of treaties with MFN language. But the peculiarity over there is when you look at Australia's tax treaties, you find a very clear mention that the MFN itself says that the other country has to be a OECD member at the time of signing of this agreement, which is missing in India's case, and hence giving rise to this whole debate. But and it perhaps also takes us back to the basic concept that we really started with, that it is a tax treaty. It is more like a commercial agreement between the two parties. It is something that needs to be read in good faith, and how this good faith is going to get twisted by either parties when the matter reaches further courts is something for us to wait and watch. But really speaking, on the first issue, in India, you don't have too much of jurisprudence. You have a Delhi High Court, which is favorable. You have some favorable guidance coming from the Australian tax treaties and how they are accepted and respected in the global landscape. But really, that is what we have so far on the first issue.
Correct. See, I think that was a sum up as far as the Styria India Limited was concerned, and this ruling has been followed in various other Delhi High Court rulings. Now, if we come to what the CBDT circular aims at achieving, now to put a rest to all the controversies that are there, mainly with respect to the two that we discussed, and to put forth their viewpoint on what the CBDT feels as far as these issues are concerned. they have kind of rendered a clarity regarding the the applications or the conditions which need to be satisfied for invoking the benefit of MFN in the tax treaties. Um, they have also spoken about the decrees that have been, or the notifications or bulletins that have been issued by the the overseas authorities. They have kind of spoken on uh, some selective invocation of the MFN clause and given their viewpoint on on that. And that's how the CBDT circular aims at kind of giving their viewpoint on each of the controversy that are associated. They've also said that once you invoke a reduced tax rate, uh, and how that is grossly invalid in absence of any notification or the conditions being followed, and that's how they have stipulated some conditions. If we move to the next slide, we'll see um, that. The MFN clause clearly has kind of provided their contention that the state has to be a member of OECD at the time of signing of the tax treaty with the third state, pretty much diverging from the viewpoint adopted by the Delhi High Court in the case of concentrics. Also, they have, with respect to the decrees or notifications that have been issued, the circular has said that it does not represent the shared understanding of the treaty partners, and these instruments have been issued without any consultation from India, and accordingly they cannot be, as far as the CBDT is concerned, they do not uh, you know uh, align to the treaties, align to the decrees that have been issued. um, Again, they have relied on the Supreme Court ruling in case of Azadi Bachao, and they have said that a notification is required to implement the provisions of tax treaty. And since India has not issued any notification for Slovenia, Lithuania, Colombia, benefits from those treaties cannot be invoked as far as the treaties of India are concerned. They've also laid out some four conditions. If we move to the next slide and see, so these are the four conditions that they have laid out, for the purpose of which need to be followed in totality for invoking the benefits. Number one being that the treaty with the third state is entered after signature of India's tax treaty. Again, the third state has to be an OECD member at the time of signing of the treaty, and India limits its taxation rights in relation to the scope or the rate of taxation with the third state, and India issues a separate notification in the tax law for importing the favorable benefits of a third state treaty into the original treaty. So these are the four conditions that have been laid out under which the benefit could be invoked. Now, a large part of the circular also talks about the dividend taxation part, but looking at these four conditions, it seems that the impact of these four clauses may have have its repercussions on the other income streams as well, whether it's royalty, interest, FTS, etc. One part which I was referring earlier also was with respect to selective invocation and application of MFN clause. So the CBDT circular has mentioned regarding the Treaty of India with Lithuania, wherein there is a 5% rate prescribed, and which has been invoked by other treaty partners. However, there has been an alternate rate of 15% where there is a threshold of 10% shareholding, which has not been kind of invoked by any of the taxpayers, and the circular has clarified that there cannot be any selective invocation of an application of MFN clauses. Circular has also kind of weakened its argument at the later part and said that for the taxpayers who have a favorable decision by court on this issue, the circular may not be applicable to them. So this is an important point the circular has mentioned, and the taxpayers would need to explore any recourse that they have available for the tax courts, since in that case the circular would not have any binding. So these were, quickly the points that are there as far as the CBDT circular is concerned. Now, what we want to discuss here is the impact of the circular on some of the popular income streams. Again, as I mentioned, the circular has developed a lot as far as the dividend taxation is concerned. So dividend basically has we can distribute the dividend aspect in two parts. One, when there was a DDT regime before 1st April 2020, where we have seen that taxpayers have been claiming the refund of the DDT that have been paid in light of the reduced tax rate that is available in the other treaties. There they have been interpreting dividend distribution tax as tax on dividend itself, and then they have been invoking the benefits that are available in Lithuania, Colombia, or Slovenia. So in that cases where there have been applications filed, the circular would really have an impact, and the tax authorities would rely on this circular for denying refund of such DDTs paid. And where alternatively, where in case there's a treaty between India and Canada where there is really no MFN in place, in such cases the circular would not have any impact, and there the taxpayers may continue to claim refund of such DDT paid, because there's no play of MFN as such. So as far as the dividend declared after 1st April 2020, wherein the DDT regime is gone and dividend are taxable in the hands of the recipient, this is where the larger part of the circular is focusing from a going forward perspective, and circular would really have a larger impact in these cases, and the tax administration would rely on the conditions that have been laid down in the circular for denying the benefit. Again, as I mentioned, even though the circular is focused on dividend, but again, the restrictive condition that have been framed would have an impact on other passive income streams like interest, FTS, royalties, etc. And the MFN clause, while invoking any benefit from an via an MFN clause, the taxpayers may need to assess the impact of the restrictive conditions, and and would need to strategize their strategy with respect to how they want to claim the lower tax rate or the restrictive definition of any income which is there in the other treaties.
Mohit, so a few points, and
Yeah.
I think that the critical part is the circular does not talk about dividend declared before 1st April 2020. Okay. It is a matter of interpretation here that whether this circular will have an impact, because DDT for a long time did not find itself caught in a controversy where the taxpayers were debating about the rate, etc. Because that didn't happen. It only started a few years back with some taxpayers and more joining the party, taking an interpretation that DDT rate, which is a domestic law provision, can also be restricted by the treaty rate. And there are two dimensions and two categories of taxpayers who've done that. First is there are a set of taxpayers who've simply said Article 10(2) of the respective tax treaty provides for a lower rate of taxation for dividend, and the interpretation there is to simply borrow that 10% and say that that 10% replaces DDT rate. The second set of taxpayers is who are relying on a MFN clause of the tax treaty, whether it is India, Netherlands, India, Sweden, and so on, where they are relying on that MFN clause in that treaty to borrow either a 5% rate from Slovenia, Lithuania, and Colombia, or to borrow more guidance to support the fundamental claim that DDT rate can be restricted by the treaty rate, because treaties like India, Hungary have some supportive language to that effect. And so MFN clause was used by taxpayers, A, to reduce the rate to 5%, B, to import a more powerful language to really support this whole claim on restricting the DDT rate to the treaty rate, whether it's 5 or 10. Again, there are taxpayers falling in each of those categories. But what I thought I'll do is just set out very clearly that prior to 1st April 2020, this debate was not specifically covered in the circular, it is not, there is no mention of dividend prior to 1st April under the DDT regime. But because how the circular operates, what it also mentions is only those cases which are decided in favor will be out of the scope. Otherwise, everything else can continue to be covered within the remit of the circular. Now, whether the circular can have a retrospective effect is something that we'll talk about. But that is really the first point. And then the last point on other income streams is primarily because the circular superimposes this requirement for a incremental notification to have been issued by the Indian government before the MFN clause can be said to be operational. And that is what really puts a cloud on everything that a MFN really can influence. And that is why what we are saying is beyond dividend, it is something that can also impact interest, fees for technical services, royalties, and so on, and business profits, like we discussed in the earlier example. So that's the broad remit of the circular.
Correct. So yeah, so moving on, we want to really touch upon how the circular would really impact on some of the existing positions that the payer or the payees in case of any income transactions would be, how the impact would be there. So from a payee's point of view, wherein he has considered any income as an exempt income, whether it's FTS, FIS, or interest. So what the effect of circular would be that the tax authorities would suppose this income to be a taxable income, and pursuant to which there will be an interest liability, because ultimately there would be no withholding that would have been taken place, and hence an interest under section 234B or C could come into picture. A penalty exposure could also come under section 270A for non-reporting of the transaction. However, this can be defended enough. Some bona fide reasons could be placed and by the SSC for interpreting this income as exempt by way of some disclosure in the return, etc. Prosecution could also be prosecution risk can also be kind of mitigated, considering the bona fide nature of the SSC's belief of claiming a MFN benefit, and that's how the interest, penalty, and prosecution can be dealt with. For the return filing aspect, the taxpayers would be required to file a return, considering now that income would be considered as taxable. For past years wherein there was no return has been filed, considering the budget amendment with respect to updated return and the facility that has been provided, the taxpayers could really look at revising or filing an updated return for past 24 months and offer this income to a tax additionally. Now, where there has been a lower rate which has been imported by MFN clause, again, where the taxpayer would be considering a 5% tax rate on dividend income, the taxpayers would, the tax authorities would argue a rate at around 10%, 15%, depending upon the treaty, and again, the interest liability may not come, and if the tax authority would really want to argue for a 234B or C, the same could be mitigated, basis some arguments. For penalty, I think since there has been no underreporting of income, 270A penalty could be avoided. And again, on the prosecution part, considering the bona fide nature of how the MFN benefit had been claimed, the prosecution risk can also be mitigated. For the return filing part, since there is no, there won't be any change in terms of income offered to tax. If the differential tax liability is paid, as such, no revision to the income tax to the tax return would be required. So these were some aspects from a payer's point of view. From a payer's point of view, where the impact would largely be similar in case of both the aspects, whether the income has been considered as exempt or where lower rate has been considered. So as far as the risk of recovery of principal tax is concerned, which has not been kind of deducted by the payer, the risk can be avoided if the payee files a ROI and kind of under section 2011, and thereby the payer could mitigate itself from being considered as a assessee in default. And the interest liability would come into picture, but till the and that would be limited to the time frame by which the payee files a return of income, and thereby such interest liability would come into picture. Again, the expenses would be disallowed, considering that no withholding was done. As far as dividend is concerned, since it's not a tax deductible expenditure, this disallowance would not be relevant here. Penalty again could be mitigated, and it's defensible if one makes a claim on a bona fide nature and is based on a legal advice or favorable view of courts, then the penalty could really be mitigated. So these were few aspects that we wanted to discuss as far as the impact of circular is there on the payer and the payee, from a going forward perspective.
I guess one important point that also needs a mention is these are the implications that will come into play if what the circular advocates to be the correct legal position is finally also upheld, or if the taxpayer is in agreement with that position, then this is what needs to be done. But
Correct.
whether the circular advocates the right position itself is a question, and the fact that no, it is in contravention with the settled legal understanding, something that Delhi High Court has really advocated and concluded on both the issues that we discussed, is a matter to debate and discuss. So it is going to take some time. It is going to go into a round of litigation before we finally hear the last word on this, in terms of what the liability or what the final legal position is going to be. But yeah, I mean, if what the circular says is finally upheld by the Supreme Court, because that is where we expect the last mile clarity, then this is what will follow in terms of consequences.
Correct. So yeah, moving on. I think one comparison that we have made, a quick comparison that we made between the arguments that have been put forth by the department in case of concentrics and the circular. I think those are two aspects we want to compare here, and which are pretty much similar. So if you look at how the revenue framed its argument before the Delhi High Court, they had argued that the benefit of the lower rate of withholding or the restricted scope would be available only if the country with which India enters in DTAA was a member of the OECD. So that's how the revenue framed the argument, and the same has been reciprocated in the circular's guidelines as well. That the treaty, the third state has to be an OECD member at the time of signing its treaty with India. Again, as far as the notification is concerned, the revenue had argued that for importing a beneficial dividend tax rate from Lithuania, Slovenia, Colombia, it is subject. It would result in a change in DTAA and could only be done by issuance of a notification, and that's how the circular has also interpreted the same way, and in the conditions for invoking MFN benefits has put forth a notification requirement. So whether the circular is really adopting a correct legal position is something that still needs to be understood, and basis the concentrics ruling, it could be said that with the circular is really following a deviating legal position that's already there. So whether, and as such, because these circular the guidance which is there in circular has already been kind of reversed by the Delhi High Court. So how correct is the guidance prescribed in the circular is something that still needs to be evaluated.
And I think the other part that also is critical is when you look, I mean, there are clearly a lot of similarities in what the revenue authorities' arguments were and what is that the circular says. So we don't see a lot of difference there. So one view of the matter is the Delhi High Court has already looked at what the circular has to offer in terms of arguments to support the tax authorities' position. So that is one dimension of the matter which is likely to give confidence to the taxpayers who want to fight it out finally. But if we look at the judgment very carefully, the Delhi High Court judgment on concentrics also somewhere made a mention that where it also spoke about need for a specific notification from India, and at that point there was no such notification from India in context of India, I mean the concentrics ruling. So now, since after this circular, that one argument will really go down, and what you really have is you have a foreign country issuing a decree which is not aligned with what CBDT's understanding is, and now CBDT has come up with its own version of what the interpretation should be. So if, I mean, with the effect that it is going to have vis-a-vis the Delhi High Court ruling in concentrics, is at least these things will even out, and what your final argument here will really hinge on this fact that the use of word is in the ruling really makes it in the treaty really makes it important that it needs to be a OECD country. It says it is, it does not say it was, and that is where the Delhi High Court has significantly leveraged on the language there to say that the intention in the treaty is to allow benefit as long as the third country from where the language is sought to be imported is OECD member at this point in time, and that use of word is what will continue to drive a lot of importance when it comes to the issue on hand in context of concentrics.
Correct. So yeah, I think that was that on the comparison front. And moving on, I think we've got some thoughts on how the circular will really bind against the taxpayers.
Yeah. So I guess the remit of a circular, and it's a popular notion which has been upheld in different judgments, Supreme Court, High Court, and there's a lot of jurisprudence that is borrowed from civil laws as well. But the final bottom line is a circular that is issued by an administrative authority, and in this context, tax authority, will have binding precedent on the tax administration only. And I mean, in indirect tax context, there is a lot of jurisprudence which also says that such circulars also bind the Commissioner Appeals Authority. Now, from taxpayers' point of view, there is enough proof to the pudding, and we also have a Pune Tribunal coming up and very explicitly, very vocally saying that this circular is not binding on tax tribunals and any appellate authority further up. And that continues to be a significant cushion that taxpayers will really heavily rely on, because taxpayers cannot be said to be bound by a circular, specifically a circular which really unsettles the settled when it comes to a shared understanding of international treaty concept or something that a high court really has ruled on. So the bottom line here is, if we just turn the page also, I think the bottom line is to say that circular will not be binding on the taxpayer. It has a binding effect on the authorities, but because it has a binding effect on the authorities, what it also means is it will certainly give rise to new set of litigation when it comes to different matters where MFN is now getting applied, because tax authorities are now bound by this, and you won't have a situation where you argue it out and convince the tax authorities to really issue it in your favor. So expect the litigation to fresh round of litigation to come up, matters to travel at least up to IT80 until the issue is put to rest by the Supreme Court. If we move on, let's also look at what this Pune Tribunal ruling is. This is a ruling that was delivered in context of India-Spain treaty, and this is in context of fees for technical services, right? And this is not in context of dividend. So let me first simply clarify that what the Pune Tribunal had an occasion to look at is a situation where the Indian entity was making payment for technical fees to the Spanish parent, and because the circular was very recent when the tribunal really looked at this matter and issued its ruling, it had the occasion to look at the circular, and there are very specific and strong observations that the Pune Tribunal had in context of this circular. What it says is it really restores and reiterates the fundamental part that we discussed at the start of our session today. It says that once a DTAA is notified, all its integral aspects, including protocol, get automatically notified. Unless, of course, the protocol itself has a language which requires a separate affirmative act of doing something for bringing it into motion. It also says that CBDT circular is binding on the AO. It is not binding on the taxpayer or the tribunal. Now, one important dimension that it also touches upon is it makes a succinct observation that this circular has the effect of attaching a disability of a separate notification, because this is the first time India has really come out with a very, very clear legal position. Until now, you had some situations where revenue authorities took the same argument, but it was not the state's official position. And now with this circular, it has the effect of creating a disability of sort, because it now requires you to have a separate notification before you import benefits of a treaty through the MFN clause. And because it is a circular which has this effect of creating a disability, Pune Tribunal has somewhere made an observation that whether it can be made operative on a retrospective basis is open to question. So what it really leaves us with is, for cases where tax authorities or appellate authorities have concluded in favor, and if they are not appealed against in the subsequent forum, those cases will not be disturbed, is one point that the circular itself clarifies. But for other cases, taxpayers would like to believe that for past years where they did not have this circular, can this circular now have a retrospective effect to go back and alter the legal position, even in years where there is no window to file a revised return now or updated return as per the new budget amendment? Over there, I think the Pune Tribunal decision really becomes a guiding light, because this concept again has been upheld in several judicial precedents, that if there is a notification or a circular which creates an incremental requirement or an incremental disability, such requirements, such circulars or notifications cannot be made applicable on a retrospective basis. Now, this is assuming that the core part of the circular stays and is upheld by the subsequent authorities, but that itself is something that, like I said, one will have to wait and watch. But apart from that, whether taxpayers will have the recourse to challenge the retrospective part of the applicability, also the answer, I guess, is yes, because there is enough jurisprudence on the basic concept that something that creates an incremental requirement or an incremental disability can't really have a retrospective effect. So these are the key observations that we wanted to share from the recent Pune Tribunal ruling. Again, not very often do you see a circular like this getting issued, and in a quick succession a tribunal coming out and refuting and trashing the whole circular out of the park. So yeah, I guess this is one such unique situation that we are in. But I think the Pune Tribunal ruling is a great relief for taxpayers, specifically in context of payments in the nature of royalties, fees for technical services, interest, etc., but not in context of dividend. Dividend has an incremental issue where the tax authorities now more powerfully, with the help of this circular, will debate that one cannot import a lower rate from Slovenia, Lithuania, or Colombia into the tax treaty and to bring down the tax rate to 5%. And that debate, I think, is still there. We don't have a comparable of a Pune Tribunal ruling on that dimension of the MFN issue yet. But again, over there, like I said, one looks at the Australian treaties, and Australia also has a treaty with Sweden. Australia also has a treaty with various other countries, and over there, Australia, wherever it intended to create that requirement that the third country has to be a OECD member, as on the date of signing of that first treaty itself, it has specifically mentioned that. And in absence of a specific mention there, one really expects that this issue is going to take longer. But between the two issues, I think the issue which requires, as per the circular, to create a separate notification for bringing that MFN clause into effect, is something that is likely to eventually get concluded favorably for the taxpayers, I presume, because that is what is in line with the global understanding and the international tax settled jurisprudence on how the MFN clause really operate. But on the second dimension, no one really expects more clarity, more jurisprudence to come through. What we have so far in the international stage is again favorable to the taxpayers, but in Indian context, after this circular, what happens specifically is something that will be interesting to see. So we should just move on, and I guess the final part of our session today. Sanju, can we move on? Yes. So the final part of our session today, and then we'll open the floor for questions. I already see some questions coming up. So just to quickly summarize the key takeaways, I think the part around whether India now with this circular has taken a unilateral position on these two dimensions of MFN applicability, because in the circular somewhere India also criticizes the other treaty partners who have taken a unilateral position. So one really needs to wait and see whether this action by the Indian administration to issue a circular is also going to be seen as a unilateral action from India, and something that really keeps that debate on before it is finally settled. And Switzerland, in fact, has already issued a reaction to India's circular, saying where Switzerland has to allow credit of Indian taxes, and if India continues to take this position and denies 5% applicability for dividend that is paid by an Indian company to a Swiss shareholder, then Switzerland will not allow full credit of 10%. Switzerland says that we will restrict the credit to 5%, and which according to them is the correct tax rate that needs to be applied in the situation. So clearly the debate is far from over, and more so in context of the exchange of communication, because the circular that the CBDT is issued also somewhere mentions about India expressing its displeasure with the other treaty partners already. But I don't know what that means from a legal point of view, because until the two competent authorities really resolve this and concludes it one way or the other, one can't really put the same in put these two in the same frame. And until then, what one hopes for is probably the matter to get consulted and decided by the Supreme Court. Now, MAP is, like I said, likely to be a option that one would look at curiously, because some MFN clauses like India, Finland already puts that power to the competent authorities to come debate and discuss where they see a favorable treatment getting extended to a third country. Now, whether the same will happen in context of lower rate of 5% being applied to dividend from these countries, I think is something that one will have to wait and see. Whether closed cases can be reopened on account of this circular if it is not already decided in the taxpayer's favor. I think one should be prepared for a round of reassessments wherever the timelines permit, or 263, 264, some of that is likely to happen, or if not anything else, a 154, because administration is likely to use is likely to come all guns blazing, looking at different options that they have to really bring this circular into motion. One other issue that also comes up is indirect application of MFN clause, which is slightly different and slightly broader as compared to the two issues that we've been focusing on so far. Now, what an indirect application of MFN clause could be. Now, let's take an example, say India, Belgium, where you don't get the benefit of, what India, Belgium says is, you can import favorable language from a treaty which India has signed after India, Belgium into India, Belgium, right? So it creates that specific requirement for you to have signed a treaty after India, Belgium. Only then can you import something in India, Belgium. Now, whereas in India, Sweden, you don't have that kind of requirement. So, and then therefore, what one can do in a India, Sweden organically is look at treaties like India, Finland, which really govern source basis taxation for technical service fees or management fees, or you look at something like India, Greece, which doesn't have a FTS clause itself, which may drive home the point that the income is not taxable in India in absence of a PE at all. Now, that bit of import can happen into India, Sweden from India, Greece, or India, Finland. Can that treatment now be imported on an indirect basis in India, Belgium? Because in India, Belgium, you can import India, Sweden. Now, that is a controversy where we don't have a jurisprudence in the Indian context yet. But again, I think you have something similar in South African context, because South Africa, again, has multiple rulings, multiple countries, multiple treaties where they have signed up with the MFN clause. And South Africa has a treaty with Sweden as well, and there was a instance where the South African court had to decide for indirect application of MFN in context of South Africa Netherlands treaty. And what they did is they imported something from South Africa Kuwait into South Africa Sweden and allowed that import into South Africa Netherlands to finally drive home the point around indirect application of MFN. Now, whether we see some of that in Indian context, I think we have some of the more fundamental issues to first debate out. But yes, I mean, the design of a MFN clause is really open and subject to that kind of potential application and debate as well. The other part that also comes to mind when one looks at MFN is what is the interplay between MFN and some of the other specific anti-avoidance rules or specific treaty requirements that are there, like a limitation of benefit, general anti-avoidance, principal purpose test, etc. Now, one view of the matter is when you import something from a third treaty, will you also import some of these incremental conditions? Now, this debate was more popular before MLI came into being, because with MLI, I think specifically from India's point of view, all treaties really have PPT as a base rule. Some also have a simplified LOB, but the debate at that point also used to be that when you import something from a third country, should it be a complete import, or can one restrict itself to only the beneficial part of it? And again, the jurisprudence that one has on the global stage seems to suggest that the design of MFN is only to import what is beneficial, and therefore you keep the incremental compliance, etc. away. But of course, even when one does that, it needs to basically satisfy the beneficial ownership type of test, because that is core to the design of passive income source articles, because whether it's FTS or royalty or dividend, all of them specifically mention for the recipient to be the beneficial owner to be able to trigger the treaty rate. And finally, I guess the last point that we want to leave all of you with is there is a subject to tax rule as a part of BEPS OECD 2.0 framework. What it says is each source state will bring in at least a minimum tax of 9%, where it finds that the country of residence, the country of recipient, is taxing it at a lower rate. So MFN, in most of the cases has a effect of bringing the tax rate to below 9% or making something non-taxable. So to that extent, if STTR comes into effect as a part of BEPS OECD 2.0, then one wonders whether this whole debate around MFN is there to stay for long, or is it really that STTR will cut the chase on these MFN nuances and finally for everything that is considered to be non-taxable or taxable at a rate below 9%, under MFN route, will now get subjected to tax through the STTR route. So it's a open point, probably early days for us to look at, but an interesting dimension, which we thought we should throw in the mix when one looks at MFN on a holistic basis. These were some of the key observations that we had on MFN as a topic from the circular, from Pune Tribunal ruling. We also discussed about how the circular has some of the specific elements which are already covered in the Delhi High Court rulings. So, in that sense, one would take confidence from the fact that there is a lot that one can rely on the Delhi High Court ruling, specifically for taxpayers who are covered within the jurisdiction of Delhi. I think they will have the Delhi High Court holding jurisdictional precedence over this circular as well. And the other dimension, like I said, is whether this circular can be said to have a retrospective basis. I think that is one issue that will be looked at and fought by a lot of taxpayers, because Pune Tribunal has just shown the light, and a lot of action is expected to happen on those lines, where at least wherever we see reassessments, etc., being opened up, taxpayers resorting to the argument that this circular cannot be said to have a retrospective basis on a without prejudice basis is something that is likely to be seen. Yeah, these are some of the closing remarks that we had on the topic. Mohit, anything else that you want to add? Otherwise, we can move to and take some of the questions that we have.
No, I think Manoj, you have covered. We can maybe take the questions.
Right. Okay, so there is one question which says, I'll just read it out. please could you explain impact analysis where at the time of payment of dividend, withholding is at 10% and then payee wishes to avail a refund of 5% by filing tax return, ignoring the CBDT circular, is there a risk of penalty? So, okay, we have a situation, a question which says, what if at the time of dividend payment, the tax withholding rate is 10%, but the recipient, when he files the tax return in India, uses the 5% rate, by ignoring the CBDT circular. If this is the approach to be followed, is there a risk of penalty? Now, I mean, penalty, I don't think should be a worry here, because taxes are being withheld at appropriate rate, which is likely to be respected by the tax authorities also. And only if the foreign company wants to file a return and claim refund for the balance taxes, I guess it is for them to look at the technical strength of the position and go ahead with that approach. Penalty should not be a worry, and there is a possibility that tax authorities, while processing that return, will not allow the benefit of 5%, and because they will be bound by the CBDT circular. So this matter is likely to go higher up before it is finally concluded. But yes, I mean, interest per se should not be an issue because taxes have already been paid, and penalty, because with right disclosure, etc., and with taxes being already paid, again, there is a good chance to address penalty part of it as well. There is one more question which says, in case of Styria India, what do we conclude? Can MFN clause be applied to India France to definition of FTS as per make available clause as well, or only to rate? Now, I think what we finally have on, so Styria, the Delhi High Court really overruled the AR ruling, which was negative, and Delhi High Court said that there is no requirement for a fresh notification. So the negative AR ruling in that sense has been overruled by the Delhi High Court. So what you today have is the verdict from the Delhi High Court. The matter is pending before the Supreme Court, and until you hear otherwise from the Supreme Court, the correct legal position continues to be to import both beneficial or restricted clause from the from India US or India Portugal into India France, or even a higher or even a lower rate. So I think both are possible.
So the point what I wanted to just add was that, STTR would be a wide animal for all of us to watch and advise to our clients on, not only for MFN, but for some other kind of withholding tax as well. And while our today's topic is on MFN, so where we are applying 5%, which is less than 9%, we have to be very cautious on that front. But really speaking, if at all there is MLI 3 on STTR, then we wonder that any treaty which has this lower rate of 5%, whether that would be at all applicable anymore, because MLI will have an overriding effect on the existing tax treaties. And therefore, we have to just wait and see that how this kind of amendments are going to take place and implemented. So thank you for this session. It was insightful.
Thank you so much, Monica, for adding that. I think what you mentioned is a great point. The only rider to that today is the current version of STTR rules says that it will apply to base eroding payments, and dividend in that sense is not considered to be base eroding. So what one will also have to watch out for is, because India will be very keen to also include dividend within the mix of STTR, because that is where India is suffering today. So only if India is able to make that effort successfully will STTR come into play for dividend. But otherwise, at least for everything else, like your typical make available type of transactions where you were taking a non-taxable position, yes, I think STTR is clearly there to cut the chase.
But most likely than not, there are discussions that dividend also may come up in the list of STTR. So while today we don't even have much clarity on all kind of royalties or FTS as well, so the wordings used are, franchisee payments, etc. So yes, currently dividend and capital gains both are not included in STTR. So we need to wait and watch if that category gets added. Most likely than not, dividend, we are expecting dividend may get added.
Right.
Yeah.